Myself, I'm a professor at the University of South Carolina. My background, and I've been there for 25 years, but you don't hear me say might could have or might should have, and I never pushed a buggy because I pushed grocery carts, because I really not adapted the Southern accent because I'm actually from Minnesota. I was a public school teacher in Minnesota for 16 years before getting a Ph.D. and going to South Carolina, and thought I'd be in South Carolina for a couple of years and come back to Minnesota or the Midwest somewhere, and that was 25 years ago. So it didn't quite work out, but loved the South, especially when it's real cold. I like the South, but it's been cold there too. But at any rate, I want to talk, in talking about general ed teachers and special ed teachers, one of the things I do a lot is, because my interest is really in the law and how the law affects us as teachers and what it means to us as teachers. There's not a lot of case law that is developed on general education teachers' responsibilities in special ed, but there is some, and it's very important. But there's also the IDEA, which is of course the federal law. IDEA, the Individuals with Disabilities Education Act, which is the federal law that has created basically a federal entitlement to special education. It was passed way back in 1975 as the Education for All Handicapped Children Act, or what we used to call back in those days PL 94-142. And it's gone through a number of changes, including having a new name. In 1990, it was renamed the Individuals with Disabilities Education Act. Now that's the federal law. You, in Indiana, your law, your special education law, of course, is called Article 7. That's the state law. And essentially, they're very similar. And the reason they're very similar is this. The Constitution only says the federal government can only do those things accounted for in the Constitution. There's no mention of education in the Constitution. So then people would say, well, why did we have No Child Left Behind? Why do we have the Every Student Succeeds Act? Why do we have the Individuals with Disabilities Education Act? Why do we have to follow those? Because those are federal laws. Well, the reason we have to follow those specific laws is because when the IDEA was passed in 1975 as the Education for All the Handicapped Children Act, essentially what the law said is, the law was passed in response to a number of what are called freedom to education cases that were brought up in like 30 states that said states have, once they've undertaken to provide education for some of their students, they have to provide education for all of their students. And unfortunately, up until the 70s, that often didn't include students with disabilities. Like when I was back in school, I didn't see many kids with disabilities because they could routinely be expelled. They never had to provide services. I still remember in first grade going into the office and seeing a woman there with her son, who what I now recognize as being Down syndrome, and the school principal was saying to her, she's very upset, she said, sorry, you can't send your son here, we don't have services. And he had no suggestion where she could get services. That's no longer the case. This law opened the door of public education to all youngsters with disabilities. And the way that this law got to school districts is because of lawsuits. Oops, I have it on. Virtually every state had one of these right to education cases. And so the writing was on the wall. States had to provide education to youngsters with disabilities because the courts were telling them to do so. But the problem was that some states were doing a great job, some states were doing not so well, some states weren't doing anything. So federal government got into the picture and passed the Individuals with Disabilities Education Act, then called the Education for All Handicapped Children Act. They also said, as part of this law, states, if you want, you have to provide education for kids with disabilities. And you also have to provide education for all students. You have to provide education for students with disabilities. Courts say so. So we'll help you. What we will do is we will pay up to 40% of your excess costs in educating youngsters with disabilities. But here's the catch. You have to pass your own law that essentially mirrors our law. And so within a couple of years, every state, with the exception of one, passed a law like Article 7 on the state level that essentially mirrored the idea on the federal level. So although I'm going to talk about both IDEA and Article 7, understand they're really the same thing. There's a little bit of differences around the edges, like you have to provide transition service for youngsters when they're 14. The federal government says you have to when you're 16. Well, whenever a state and a federal government differs in their laws, you got to follow the state law. And the states cannot provide less than the federal government. So for example, the federal government says that youngsters with emotional behavioral disorders are eligible for services under the IDEA. A state could not say, well, we think those kids are a lot of trouble, so we're not going to let them be eligible in Indiana. We're going to just leave them out of Article 7. State can't do that. States got to follow the federal law. You can provide more, but not less. So when I talk about requirements from the IDEA or interpretations of IDEA requirements by courts that not Indiana courts, basically IDEA, Article 7, same thing. Same exact thing. So the first thing I want to talk about is some reasons why it's so important that general education teachers be involved in special education. Number one, it's law. Article 7 and the IDEA require that teachers with general education teachers be involved in educating youngsters with disabilities. And we know that nationally about 80 to 85% of all youngsters with disabilities spend between 70 and 80% of their time in the general ed classroom anyway. So you're going to have kids with special needs in your classes, and the law says you obviously have to serve those youngsters, and also there's additional responsibilities. Like if you have a child, you may be on an IEP team. Or I should say, that's the federal terminology. We in Indiana use the term case conference committee. And this is the law. Now, here's an important thing to understand about special education. I am, in South Carolina, I am what is called a due process. In addition to working at the University of South Carolina as a professor, I am also a due process hearing officer. Now, the interesting thing about IDEA and Article 7 is they're both set up essentially on somewhat of an adversarial model. And what that means is who wrote the IDEA? Well, they were lawyers in Congress who wrote the IDEA. And what lawyers also always do, they always think about, well, what happens when things don't work out? What happens in special ed when things don't work out is parents or school district personnel can file a complaint with the State Department, and the State Department will investigate it. Or they could file for what's called a due process hearing. And a due process hearing, from 2000 to about 2015, I was a due process hearing officer in the state of South Carolina. Well, what happens is there's an IEP meeting, which of course here would be the case conference committee, and the parents and the school district are collaborating, but there's some aspect of their child's education that they just don't agree with the school district. They want something provided to their child that's not provided. The school district says, no, we're not going to provide those services. Well, under the IDEA in Article 7, the parent who disagrees and cannot solve their problem at the case conference level does have an opportunity to request what is called a due process hearing. A due process hearing is held before a hearing officer, like I was in South Carolina, and it's at the local educational agency. So let's say I have a local school district that asks me to come in and serve as an impartial hearing officer. I can't be employed by either the parents or the school district. I'm impartial. I come in and act like a judge. And I have a table set up a table over here for the school district and a table over here for the parents. almost always both are represented by attorneys. And there's teachers present, like general ed teachers, special ed teachers, and I will ask the, it's just like going to court. I might ask the attorney to give an opening statement, the school district attorney, then I turn to the parents and I ask their parent attorney to give an opening statement, and then the floor is open to first, however I want to do it. If it's a school district, please introduce your first witness. I have a chair and a witness chair up here, and he might say, I would like the student's general ed teacher to come up and testify. So general ed teacher comes up, they testify, special ed teacher. Then I turn to the parents, say, would you like to cross-examine? And so they do a cross-examination. I mean, it's just like going to court. And then I have to take the facts of the case. And they have different facts, but I've got to determine who I think is having the best, who have the actual facts. Then I look at the facts, I look at the law, the idea, or if I was here, or in Article 7 maybe, if I was in Indiana, I look at all the evidence, listen to all the testimony, read the briefs of the attorneys, and then I make a decision. Which team prevail, or which side prevails? Does the parent side, or does the school district side? And I render a decision. Now, in Indiana, either party that loses can then file with a suit with federal or district court, or federal or state court. And almost always in the United States, suits under IDEA are filed with the federal courts, not the state courts. So the court's really interested in IDEA and how does did the facts of the case match up with IDEA. If it was a state court, they'd be looking at Article 7, but it's a federal court, so we're looking at the IDEA. And then I make a decision, and the losing party may then appeal it. Like I said, in South Carolina, they appeal to either the state or the federal court. In Indiana, they appeal to the state. And I'm a state review officer, so what I have to do is take these boxes I get of testimony and evidence, and then I have to decide if the impartial hearing officer made their decision correctly. And then the party that doesn't prevail can go to federal or state court, and again, almost always they go to federal court. Well, why is that important? Why that is important is that is the beginning of the litigation process in special education. And special education is the most highly litigated area in education, not even close. In special education, we serve 10 to 12% of all students in public education, and yet special ed cases account for 90% of all litigation in education. By far and away, the most frequently litigated area is special education. And that's because Article 7 and the IDEA grants specific rights to students with disabilities and their parents that youngsters without disabilities don't necessarily have. And so that's one of the reasons it's such a litigated area. It's highly litigated. And how this is important is this. If errors are made at the case conference level in Indiana, or at the IEP level in South Carolina, or most states, errors made at that level, that's where litigation comes from. So every case that's ever been heard in special ed, even there's been, depending on your count, 12 to 13 cases heard in special education by the United States Supreme Court. Every one of those cases started at the IEP table, at the case conference committee meeting. And for some reason, there was a dispute that couldn't be solved. And so the parents or the school district used these due process or procedural safeguards. And one of the due process or one of the procedural safeguards of IDEA says this, is general education teachers have to be involved in not only developing the individualized education programming, but ensuring that its general ed components are implemented. So that's why It's so important. Now, like I said, there have been fair amount of due process hearings involving general ed teachers, but not a lot of cases. But what we know of the few cases that have been heard on general ed is they just emphasize how extraordinarily important the role of the general ed teacher is before, during, and after the case conference committee. So what I want to do is start out with a few cautionary tales. And they're from cases that have been heard. Now, I don't want these to scare anybody, but just to understand the importance that the law puts in having the general ed teacher on the IEP team. The first was a case out of the 6th Circuit. You're actually in the 7th Circuit, so you're real close by. It was a case called Deal v. Hamilton County Board of Education. Involved a little boy named Zachary Deal. Zachary was a 3rd grade student with autism. And he had a severe disability, but he did okay in some of his classes, and he had language, and he wasn't a behavior problem. So he spent a good part of his day in general ed, as most youngsters with disabilities do. Spent his day in general ed classes with the general ed teacher. Well, when he was going into 4th grade, the parents had gotten to be kind of upset with the school district. Because they said the last 3 years of IEPs, and there's more to the case than this, and I'll talk about that later. The last 3 years of IEPs, even though Zachary's in general ed, the school district didn't have the general ed teacher in the IEP team, or what in Indiana we'd call a case conference team. And so they said, we don't think this school is conferring what the law says they have to confer, which is called a free, appropriate public education. As special educators, we write IEPs that confer a free, appropriate public education. That's the terminology used in both Article 7 and IDEA, that our programs have to confer a free, appropriate public education that allows a child to progress appropriately in light of their own circumstance, their particular circumstances. Well, Zachary's parents said their IEP doesn't do this because they had the case conference, I'll refer to it as the case conference, and they didn't have the general ed teacher there for 2 whole years. No general ed teacher. 1 year they had the general ed teacher there. They came in for 5 minutes and they went out. And so we don't think this offers an appropriate education. And they went to a due process hearing, and the due process hearing officer agreed with the school district. They said, no, yeah, the general ed teacher is very important to be there, but just because they weren't there, that doesn't mean the school district didn't provide a free, appropriate public education, because Zachary had benefited some. And so the parents, undaunted, sued in district court. District court upheld the hearing officer saying, yes, yeah, the general ed teacher should have been there, but they weren't. But there's still student progress, so he did okay, despite the lack of a general ed teacher. Then the parents, undaunted, sued in the next higher level of court. First was the U.S. District Court. Then they sued in the U.S. Circuit Court of Appeals. And in that case, it went before the Court of Appeals, which is actually a 3-person panel of three judges who essentially read the case, look at the facts. They don't rehear the case. They look at the facts of the case. They look at the exhibits and read the briefs and make a decision. What they did is they found that the school district had failed to provide a FAPE. Why? Because they didn't include a general ed teacher on the IEP team, or on what we'd call a case conference committee. And the other courts had recognized that. They said, well, you didn't have a general ed teacher. Well, the Deal court said that, but the lower court said, yeah, you didn't have a general ed teacher, but that didn't deny a free, appropriate public education because Zachary did benefit. The circuit court, which is right under the Supreme Court, said, oh no, the general ed teacher is a vital component of a child's IEP team. You have to be there. And by not having the teacher there, and in one case having the teacher come in and go out, you violated the idea. Why? Because we always have to keep this in mind, that the proper place to educate a child is in the general ed classroom. The whole idea of special ed is remove the child and provide remediation and try to move them back when possible. But it's very important that we always keep in mind the general ed curriculum. That's why you have a general ed teacher on the IEP team. So this school district lost this case, wound up paying pretty hefty attorney's fees because of the failure to have a general ed teacher on the IEP team. Like I said, now there's a few other things involved in this case that I'll talk about a little bit later. That case was brought under the idea, the Individuals with Disabilities Education Act. Now, the federal law. Most all cases brought in special ed are brought under that law, under the idea. But our next case was not. This was a case called Doe v. Withers. It was a case in West Virginia in 1992. And this is, again, it's not likely to happen, and I'll explain why in a second, but it did happen, and the results of this case are important to understand how vital the general ed teacher is on the IEP team. And I've mentioned this before. The IEP Resource Center has the IEP at a glance, a wonderful tool to help inform all teachers. Because when you have a child with a disability in your class, even if you're not on the IEP team, you are still responsible for carrying out the certain modifications on the IEP. But let me go back to Doe v. Withers. So what happened is there was a young man, he was in 7th grade. The court called him John Doe because they usually don't use names of minors or in these type of cases. John Doe was a student with a severe reading problem. But he was otherwise, he had a learning disability. He was a very bright child, but he couldn't read. And he was in a middle school in West Virginia. And what happened is he had an IEP meeting for when he was going into in the middle of 7th grade. He was ready to go into 8th grade. They had an IEP meeting in the middle of 7th grade. And, well, it's actually toward the end of 7th grade. And what happened is special ed teacher was there, as is required under the law, and a general ed teacher was there. In this case, there was a couple general ed teachers there. There was John's science teacher, his health teacher, and his social studies teacher. Well, so he had 3 general ed teachers, special ed teacher, the LEA rep who was the principal of the school psychologist was there, and they had an IEP meeting. And in the IEP meeting, they were talking about goals and objectives and things like that, and they got to talking about modifications in general education, because John spent an hour a day in special ed and 6 hours a day in his general ed classes. And so they talked about what's very important. What are we going to do in general ed? Well, the health teacher spoke up, and the health teacher said, you know, the science teacher spoke up. John is a great student. He really likes science. He participates in all the discussions. But, you know, if I give him a test, and most of my tests are essays or short answer, if I give him a test, he's going to fail. Why? Because he can't read. He couldn't read. He was reading at a primer level, even though he was in 7th grade. So what the science teacher said, what I do is I assign one of my most trusted students to read the test to him, to go out and read the test to him. And then John says what the answer is, and my student writes it down. So in essence, he had a peer reading John his test. And the IEP team talked about this, and they said, well, that sounds like a great idea. That makes real sense. Let's have this program modification. John is going to, in all his general ed classes that require reading, have tests read to him so, you know, he can pass the test. And so that was written into the IEP, and lo and behold, at the end of the semester, John came home with his report card, and he had an A in health, he had an A in science, and an A in art, and in social studies he had an F. And the parents said, well, John, what happened in social studies? You love social studies. You come home and talk about what you're learning every day. What happened? He said, Mr. Withers wouldn't read the test to me. So I didn't know what they said, so I would write something down, but I failed all my tests. And well, the parents were pretty upset because they looked at the IEP and says, oh, wait, it says here all general ed teachers will read tests to John. Mr. Withers did not. I want to talk to Mr. Withers. So they got the principal, and they got Mr. Withers, and they went into the principal's office, and they said, you know, the IEP said you were to read tests to John, but you didn't do it. And he failed because of that. And the principal turned to Mr. Withers and said, well, what's the deal here? And Mr. Withers says, you know, you don't understand. I have got 120 kids a day. I can't make changes like this for kids because in my class is a level playing field. Everybody is treated exactly the same. So for there, it would be, I would not read tests to anyone because everybody's treated the same. Well, right there, Mr. Withers didn't understand what special ed at all is about because the purpose of special ed is to level the playing field. The playing field was not level when John couldn't read the tests. So by reading the test, he would have leveled the playing field. Well, parents were real upset. What do you suppose happens when people get upset nowadays? They turn to litigation. And they could have sued the school district under the Individuals with Disabilities Education Act, and they would have won easily, and the school would have wound up paying a lot of attorney's fees and everything else because they violated the idea and didn't provide a FAPE. But you know what they did? They didn't do that. They sued under a federal law called Section 1984 of the Federal Criminal Code. And what that law says is all people acting under color of state, policemen, firemen, teachers, people who work for the state in essence, have to, if they knowingly violate a law, they can be held personally responsible and personally liable for violating the law. So they brought it before in essence, a criminal court, it was a civil court, and there was a jury, and the parents sued the principal and special ed teacher, every one of the general ed teachers, and the first thing the judge did is he threw out every case except the case against John Withers, social studies teachers. Allowed that to go forward for a jury trial. And what happened is the jury found John Withers had knowingly violated a federal law, which in turn violated Section 1984 of the Federal Criminal Code. And what happened is John Withers wound up paying a fine of $25,000 because he knowingly said, no, I'm not going to do that. Now, that was a very unusual case because mostly attorneys for parents go after the deep pockets. They want to go after the money. Where's the money? It's in the school districts. So more than likely, they would have won easily under IDEA, and they could have wound up having to pay for tuition and attorney's fees and all this, but the parents were so upset they went this other route, which is perfectly legitimate. And they went after everyone, but they wound up getting John Withers because he knowingly refused to follow a federal law. The idea is a federal law, and he didn't follow it. The idea is not a list of suggestions. It's not, here's some things you could do. If it's in the IEP, that's what has to be done. That's what the law says. Now, the last case I wanted to tell you about, and this is just almost kind of a humorous case in a way, it's so weird, called LSV Mount Olive Board of Education back in 2011. Involved a general ed teacher and a special ed teacher, and working in what the school district, the Mount Olive School District, called an inclusion class. In other words, they co-taught. The general ed teacher was an English teacher, and the special ed teacher went into the English teacher's class. Well, they went into the class, and this is another warning, I guess. The English class was reading a book I think every junior high kid reads called Catcher in the Rye. Anybody read that? I know when I was a student, everybody read that. So the major protagonist in that book is a young man named Holden Caulfield. And Holden is going through all these adventures and things like that. And so they read the book, and the English teacher gave all the class an assignment. And the assignment was to write a psychological profile of Holden Caulfield. And sounded good. She explained what a psychological profile was and said, that's your homework tonight, write a psychological profile. The kids, the special ed kids, of whom there were 11 in the class, went to the special ed teacher and said, psychological profile, what's that all about? We don't know how to do this. You've got to help us with this. So the special ed teacher said, well, you know, I've got an idea. My friend is a school psychologist in the school. She writes psychological reports all the time. And so I will ask her to come to talk to you about what constitutes a psychological report. Well, that makes sense. But she went to the school psychologist and said, oh, heck, I don't need to go talk to him. I'll do you one better. I'll give you a psychological report from one of the students. And so what she did is she crossed out the students' names. The student was actually one of the students in that English class. She crossed out her name, gave it to all the kids, and the kids said, wow, this is great. This tells us how to do it. And then the English teacher got whiff of this and said, could we do this for all the kids? So the next day, she passed out this psychological report to every student. And they were all reading it, and suddenly some student stands up and says, hey, this is about Susie. And because they had forgot to get rid of her address, they had forgot to get rid of her parents' names. And so, as you can imagine, when Susie went home, she was quite upset, told the parents. All the class read the school psychologist's report on me that had all this information about disabilities and things. Parents were upset. They brought suit, but again, they didn't sue under the IDEA, which they could have done. Or they could have sued under another law called the Family Educational Rights and Privacy Act, but they didn't do that. They sued under Section 1984 of the Federal Criminal Code. And they said that the English teacher, the school psychologist, and the special ed teacher had knowingly violated a federal law, the Family Educational Rights and Privacy Act, FERPA, by giving this information out. Well, they said, well, we redacted her name. Well, you didn't redact enough because everybody knew who this was about. And so what happened then is it went to court, and the judge said, this can go to a jury trial. In other words, if you looked up LSV Mount Olive Board of Education, the last thing you'll find is the judge allowed the case to go forward. Anytime you see that, that's code for the school district attorney got together with the other attorney and said, how big should the check be? And that's what happened. You'll never hear another thing about this case because the school district probably paid a pretty good amount of money to make the case go away. So again, when I tell you that case, you go, I saw all the eyes rolling and think, what were they thinking of? But still, that's an example of not following the law. And these aren't going to happen a lot. What's going to happen more often is this type of thing, because attorneys really go after the deep pockets, which are school districts. We had a case, Carter v. Florence, in South Carolina, and it didn't involve, in this case, a general ed teacher, but it involved a suit against a school district because they had failed to confer FAPE, which is exactly what happened here. Now, in the Deal case, they failed to confer FAPE. Why? Because they didn't have a general ed teacher on the IEP team. In our case in South Carolina, and this was back in the early 80s, it was a different issue. It was that they had written goals and objectives that were not ambitious. And for that reason, they were sued for not providing FAPE. Well, anytime a parent believes a school district does not provide FAPE, they can unilaterally pull their child and put him in a private school. and then later go back and sue the school district for failing to provide a FAPE. And if they prevail, they can get tuition reimbursement for the private school, which they did in this case. In the Carter case, the judge said you didn't provide FAPE, your goals were not ambitious enough, they weren't meaningful, you didn't provide FAPE school, you have to pay $36,000 in tuition for 4 years of, at Trident Academy. And that, of course, wasn't the end of the story, because IDEA has an attorney's fees provision that says, in essence, that if you sue, if a school district gets sued and the parent wins, the school district can be responsible for tuition reimbursement and attorney's fees. What happened is the school district wound up paying $36,000 in tuition reimbursement, $1.5 million in terms for attorney's fees. So there are big stakes involved for school districts, and as you can see in this case, there's also potential of individual liability, but in reality, that's not something we ever have to worry about, because we should be following the law, right? We shouldn't have to worry about that. Now, the second reason we need to know that is because the IEP is kind of like a contract. In a way, it's like a contract. In a way, it's not like a contract. Here is how it is like a contract. It's a promise in writing that we will provide, as a school district, will provide certain special education, related services, supplementary services, program modifications that are listed in the IEP. That are listed in the IEP in order to provide FAPE, because a FAPE is defined by what is in that, what that case conference committee puts in the IEP. Now, the IEP is not like a contract, and it doesn't guarantee success. You'll often hear people say, oh, it's not like a contract at all, and it's not, and it doesn't guarantee student success. But what it does guarantee is that we will implement all the things we said we'd implement. Like if there's a program modification that says all general ed teachers will read tests to their child, if that's in the IEP, we have to do that. We have to honor that, because that part is like a contract. It's drawn up between the parents and the school district personnel saying this is what we'll provide. Now, to the extent that those things are not provided, the school could possibly wind up violating the law. If a court or hearing officer later determines that FAPE is not provided. So, doesn't guarantee success, but it guarantees good faith efforts and the provisions of all the services and program modifications that we said it would. Reason 3, student's IEP must ensure that he or she is involved in the general education curriculum. That's in IDEA, it's in Article 7, that goals and objectives, assessments must always kind of be aimed at the idea that a child, all children are general ed children. Certain kids with disabilities need special services, but they're still, in essence, general ed students. And we have to always keep in our mind the idea that they need to be involved in and progress in the general ed curriculum. The statewide standards apply to students with disabilities, just as they do to students who do not have disabilities. And to that extent, then, the general ed teacher is actually the representative on the case conference committee who has the greatest firsthand knowledge of the general ed curriculum. I mean, as a general ed teacher, you know what is being taught in the general ed curriculum. That was the original reason for including the general ed teacher on the IEP team. In fact, when I was teaching, the law didn't require a general ed teacher, just required a teacher. Didn't matter who it was, just so was the child's teacher. In 1990, it went to the child's special ed teacher and the child's general ed teacher. In 2004, it was changed to the child's special ed teacher and the child's general ed teacher. In other words, the teacher who works with a child has to be on the IEP team. Now, because you know that most kids have more than one general ed teacher, you only need one. You don't need multiple teachers. But that was the original reason for putting them on the IEP team, because they have firsthand knowledge. of what is involved in the general ed curriculum. Secondly, or fourth, I should say, vast majority of students with disabilities spend most of their school day in the general ed classroom. National statistics show that about 85 to 90% of all kids with disabilities spend at least 75% of their day in general education. And that's true even of kids with more serious disabilities. Because the IEP is written for all of education, not just special education, that means the general ed teacher is going to be responsible for a lot of these things. That's what happened in the Doe v. Withers case. Say if you have that modification listed that you're going to read tests to kids, and all general ed teachers are, and that's in the IEP, and it's signed by the LEA representative and the teachers and the parents, that's the contract part of the idea. We have to do that. The fifth reason is general ed teachers expected to suggest behavioral interventions and supports and supplementary aids and services. Both Article 7 and the idea, I should say the regulations to the idea, talk about the general education teacher and how they're expected to be involved. And they specifically state, and I think this is in Article 7 also, that one of their roles can be to suggest what kind of interventions, behavioral interventions, might be used in the general ed classroom if the child has problem behaviors, or what kind of supplementary aids and supports could be provided to the child in the general education classroom. And additionally, the general ed teacher is at a great position to be able to observe the child and note how the child is doing in the general ed curriculum. Now, the sixth and the final reason it's very important that general ed teachers be involved is because a student's IEP will often, more often than not, include accommodations and modifications to the general education classroom. Now, when those modifications and accommodations are there, once that IEP is signed, it's like a contract, those things have to be implemented. And that means essentially that John Withers, if it says the test is going to be read, he's got to read the test. That's what the child's IEP says. That's part of the child's FAPE, or free appropriate public education. And to the extent that those things are not done, that's a violation of law. That's a violation of the idea. Could possibly mean that the school district is not providing FAPE. Like in the case, like I said, of John Withers before, when those accommodations in the IEP, say the parent probably could have easily sued under IDEA. And if a parent sues under the IDEA, there's no personal responsibility. If I'm a teacher, you're a teacher, special ed teacher, general ed teacher, we have a principal, they can't be sued individually under the IDEA. There's no individual suits under the IDEA. The school district, however, can be sued. And the school district can, if they're found to have violated the IDEA, in which case their one person who violated the IDEA was John Withers, it's very likely a hearing officer or a court would say, you did not honor the IDEA, you violated the child's FAPE. Because, yeah, just John Withers didn't honor it, but nonetheless, the IEP was not implemented as written. And therefore, you violated the law. So, if they had sued under IDEA, John Withers would have never paid a penny. The school district could have been socked for, millions if they had, because they went all the way up to a circuit court, which requires a lot of lawyer time. And remember, under the IDEA, attorney's fees can be paid if a parent prevails. Now, a general ed teacher's role is not as involved as a special education teacher. As special education teachers, we are generally what the state of Minnesota calls case managers. We're the ones who really kind of shepherd the IEP process through from assessment to writing the IEP to delivering the special ed services in the IEP. Well, a general ed teacher does not have the responsibilities are not as complex for a general ed teacher on the IEP team. But you do have to honor the IEP. Now, in fact, in 2004, Congress was really concerned. They said, well, you know, general ed teachers have so many kids and there's so much responsibilities. We want to make this easier for them a little bit. And so what they did is they, and this is in Article 7 too, allowed that teachers be excluded. And this is from the idea and from Article 7. If a member of the case conference committee can be excused if the member's area is not being discussed. Here's the deal. You can be excused from, if your area is not being discussed, let's say we're having an IEP meeting, but we're not going to discuss general education modifications. The parent, the LEA rep can say, well, Mrs. Johnson unfortunately is sick today, cannot make the meeting. Would it be all right with you if we just keep the hold the meeting without Mrs. Johnson? We're not going to discuss her area anyway. And if they say, okay, there's a form that you can sign, the parent signs, no problem. However, if your area is being discussed, say it's an annual case conference. We're going to talk about, one of the things we're going to talk about is modifications or accommodations in the general ed classroom. LEA represents, you know, Mrs. Johnson is sick today. Unfortunately, she can't make the case conference committee. But what she did is she wrote notes. And I'll read her notes and we'll discuss it and she will get all this information. Is that okay with you? If the parent says, okay, well, would you sign this then? And then you're fine. You know, actually, and I kind of do nerdy things like I like to read a lot about the law, so one of the things I'll read is the testimony that was heard and everything. The reason they did this is in essentially saying if a general ed, the reason they did this was to excuse the general ed teacher because they realized that general ed teachers have pretty heavy, you know, they have a lot of work to be doing and they don't need to be attending meetings that they're not involved in. So let's give them a way to excuse them. And of course, you have to get parent permission. This was for if an emergency really comes up and you're sick, but your area is being discussed, that's when you have to come up with someone else who can sit in for you with parent permission, or you write a note and get parent permission to do that. So you can be excused. See, virtually every state has kind of their own way of doing it, but they have to, at a minimum, do what the federal government says. And that's what they say. You need parent permission. But that's there as kind of, again, if you're sick, fine. If you just are not involved, don't take your time. Now, I've been talking about free appropriate public education, so I want to spend a little time on that. That is what the federal government essentially says. We as special educators have to provide a public expense. This is actually from Article 7. Special ed and related services that are provided public expense under public supervision, direction, and no cost to parents. That means if they have something like you will have a para assigned to a child in general ed classes, they can't say, oh, but you got to pay for it. You know, if it's in the IEP, we have to pay for it. The school has to pay for it. Meets the standards of the state educational agency. I said that. Appropriate early childhood education, elementary or secondary education. This applies to children from age 3 to the day they turn 22. They are entitled to receive a FAPE unless they graduate for get a legitimate diploma. Then it stops at 18. Now, every state also, but usually not under, I don't know if it's under Article 7 here, but they also do have services from birth to age 3. So kind of real early childhood. And provided in conformity to the IEP. So that's the touchstone of the law. The IEP is the child's FAPE. So if it's in the IEP, we have to honor it. So in essence, before, what's our involvement before? Well, the general ed teacher, the way they're most frequently involved before the case conference committee ever happens isn't something called child fine requirements. This is what Article 7 says about child fine. That the public agencies shall establish, maintain, and implement written procedures that ensure the location, identification, and evaluation of all students age 3 but less than 22 years of age who are in need of special ed and related services regardless of severity of their disabilities. So essentially, schools have affirmative duty to go out and look to find children with disabilities. Well, in every school has a kindergarten roundup where they test, and possibly students may get services that way. But the way nationally most kids get referred to special ed are through general ed teachers. General ed teachers tend to be really good at seeing when children are having problems, academic or behaviorally, because you have a big database of what is kind of normal student behavior. And when you see behavior that is markedly different for some reason, a child is not learning to read, you recognize that. And the way school districts handle that is to have a referral process where the general ed teacher can refer the child to special education teacher. So that's really how a student or general ed teacher gets involved prior to the case conference committee, is through the referral process. And I know all your schools have referral systems. Some states have referral systems that all schools use. Some states allow schools to set up their own referral system, but you will have them. In Indiana, if you move to South Carolina, that's one of the big responsibilities of general ed teachers, is when you see a child having problems, you refer them to special ed. That means they may be further tested for inclusion in special ed if they're eligible. And in fact, nationally, we know that 90% of all kids that get referred from general ed teachers get further tested for special ed. In other words, teachers are really good at spotting problems, and that is where you're involved before. Now, during the case conference committee, the basics we've been talking about, you're on the case conference team and the content. Now, in terms of being on the case conference committee, the IEP team involves the students' parents have to be there. The LEA rep, who's usually a principal or assistant principal, is there. And what they do is they're supposed to be knowledgeable about general ed curriculum, and also they're able to commit school district resources. So when they sign on the line, that means our contract is complete. We commit school district resources. The special ed teacher, who becomes in essence kind of like a case manager, who oversees most of this process. The general ed teacher, actually the federal government uses the term regular ed teacher, but most states refer to general ed teachers. And that is at least one teacher of the child. You don't have to, if you're in middle school or in elementary school where a child has 5 different teachers, only one is required to be on the IEP team. And we have to have a person there who can interpret the instructional implications of the evaluation. In South Carolina, that almost always means the school psychologist will be part of the IEP team. By that asterisk, I mean it doesn't have to be any school psychologist. It could be the special ed teacher, could be the LEA representative. Now, what Article 7 says is this: not fewer than one of the student's general ed teachers if the student is or may be participating in the general education environment. Now, that raises an interesting point that somebody asked me about in the previous session. She was a self-contained teacher and had no general ed teachers who worked directly with the child. What do you do then? Well, I didn't see anything in the idea, and I didn't see anything in Article 7 that says you don't have to have a general ed teacher there. Because the general ed teacher has to be there if the student is or may be participating in general education, or may be participating. So in other words, if you said, well, we're not having a general ed teacher because your son will never be in general education, you know what you're doing? You're predetermining the child's program and placement. That's illegal. You can't do that. So by all intents and purposes, we can't say that a general ed teacher doesn't need to be on the team. I think they need to be. In the case of a special ed, of a self-contained teacher, there should be someone brought in who can address general education. I did want to say, now when I first started teaching, you know, a general ed teacher wasn't required, and that was until 1990. And so I remember still, you know, we'd have our, what we called in Minnesota, an IEP team, and you call the case conference committee, and the general ed teacher who tended to be there was some poor general ed teacher who passed the room and had the unfortunate, was unfortunate enough to make eye contact with the principal. And he said, get in here, get in here. But it can't be that. It's got to be someone who's actually involved in helping develop the IEP. And in fact, Article 7 says the general ed teacher who's a member of the student's case conference committee must, to the extent appropriate, participate in the development of the student's IEP, including determination of appropriate positive behavioral interventions and supports, supplementary aids and services, program modifications and supports for school personnel. In other words, you're not just there to sit, or as Julie Weatherly used to say, a warm butt in a chair. You're there to actually be part of the process. In terms of the content of the IEP, of course, that's where the general ed teacher is most likely to be involved, because the supplementary services, accommodations, and program modifications are really to help the child be involved in the general ed curriculum. Things like the measurable annual goals, the monitoring and reporting progress certainly involve you, and you may be asked to fill out quarterly reports or weekly reports on how the child is doing, and that's a part of progress monitoring. For the most part, though, those things are handled by the special ed teacher, but these are really the province of the general ed teacher. And these are just some examples of supports in curriculum: adapting the curriculum, providing notes, allowing students to work in small groups, large print books, reading tests, any of these kind of things could be accommodations. I've just got to tell you this too. I've been in IEP meetings where we get some pretty out of left field comments. If you ever hear anyone saying this, kick them under the table. If you say them yourself, kick yourself. If I do that for your child, I have to do it for everyone. No, you don't say that. That's not the way I teach. I won't make exceptions. It's my classroom. I don't care what the law says. This is what I do. I don't play favorites. I treat all children the same way in my classroom. All students on a level playing field. You want to avoid comments like that, you know, because this is about special education, about accommodations. And remember that after the IEP meeting, the IEP is like a contract in that it's not a guarantee of success, but it's a guarantee that we're going to deliver the services we said we deliver. When that LEA rep and that parent signs it, it's ironclad. These are the services you're going to provide. And as general ed teachers, as special ed teachers, we have to make certain that those services are provided as written. So, well, that's our time, so thank you very much.